Not is an unconventional take on the Kashmir issue and places the Kashmir issue in context of the partition of the Indian subcontinent. Comprehensive yet accessible, the book critiques the current political discourse on the Kashmir issue. The book plucks lesser-known details about the partition from obscurity and emphasizes their importance for charting a realistic path forward to resolve the Kashmir issue that appears to have so far escaped consideration. Dr. Aman Hingorani is a senior advocate and mediator at the Supreme Court of India and Delhi High Court, and also acts as an arbitrator at several institutions in India and abroad. Dr. Hingorani has been adjunct faculty since 1998 to teach law students around the world and has run training courses for judicial officers, lawyers, and law teachers. He's an international trainer for advocacy and mediation skills and has prepared the curriculum for several academic and professional training examinations. He was requested to give expert evidence on the Mediation Bill 2021 by the Indian Parliamentary Standing Committee on Personnel, Public Grievances and Law and Justice, and many of his recommendations have been reflected in the Mediation Act 2023. Dr. Hingorani has received wide recognition for his decades of work on the Kashmir issue. He has given expert evidence on the subject before the Foreign Affairs Committee of the UK House of Commons. Apart from this book, Dr. Hingorani has another 83 publications, both national and international, on varied subjects, ranging from public interest litigation jurisprudence to the Bhopal gas tragedy, to mediation, to the grant of intellectual property protection, to genetically modified organisms, and to the dynamics of global missile proliferation. Dr. Hingorani will be in conversation tonight with Professor Sam Adelman, a distinguished professor of law at the University of Warwick. Professor Adelman holds degrees from the University of the Witwatersrand, Harvard University, and Warwick University. He teaches legal theory and comparative human rights at the undergraduate level and several modules in the LLM in international development law and human rights at the law school at the University of Warwick. Professor Adelman, known for his struggle against apartheid, is also a visiting professor at the Nelson Mandela University in South Africa. He is a member of the senior editorial board of the Journal of Human Rights and the Environment. He has been a Fulbright scholar and was awarded a British Academy Leverhulme Senior Research Fellowship in 2020. Professor Adelman's writings cover legal theory, development, and human rights, and he is currently completing a book on sovereignty. We are delighted to have with us this evening the Right Honorable the Baroness Nicholson of Winterbourne. Baroness Nicholson is a member of the House of Lords and has been a life peer since 1997. She is a member of the All-Party Parliamentary Group for Human Trafficking and also chairs the All-Party Parliamentary Group for Foreign Affairs. She was a member of the European Parliament for South East England from 1999 to 2009 and the rapporteur for Kashmir. She also serves as the executive chairman of the Amar Foundation, which works to rebuild and improve the lives of disadvantaged communities in war-torn areas. May I request Dr. Hingorani, Professor Adelman, and Baroness Nicholson to please come up on stage to officially unveil the book. If you could say a few words, that would be very kind.
Thank you all very much indeed for giving us the opportunity to celebrate this wonderful book. I've had one edition already, which the High Commission kindly brought round to me, and I've delved into it with fascination. I am not a lawyer, I'm a politician, but I had the opportunity to work for a couple of years in the European Parliament on the Kashmir issue. And as a result, we have a big report that came out in 2008-9. It was the biggest report ever written by the European Parliament, and unlike most foreign policy reports, it altered the policy of the EU. And that was what was so interesting with it. Normally, the Parliament doesn't alter policies, but we felt so strongly about the Kashmir issue when we had finished our report that we actually made policy, which means that 500 million European Union citizens agreed with the points that we made. And we had a very, very interesting time doing it. We had enormous numbers of visitors. We went to see Kashmir on both sides of the border. And it was a huge opportunity to try to help to resolve the issue that is correctly identified by this wonderful book as an absolute knot. Somebody has to unravel it. And this is the legal understanding of how to unravel it. We believe that from the European Union we may have helped you see the political way of helping unravel it. And at the end of the day, of course, it's the social way on the ground, what the Kashmir people themselves want and find best for their futures, that is the most important thing of all. So this book is of fundamental importance, and I believe that its findings will last for many, many years. Thank you so much for inviting us all to celebrate this book.
May I request Priya Hingorani to present the Baroness with a small memento. We will now begin the main segment of this evening. Dr. Hingorani will be in conversation with Professor Adelman for about 40 minutes, after which we will have Q&As with the audience. If I could request Dr. Hingorani and Professor Adelman to please come up on stage. I would also request Mr. Arpit Agarwal to please present a small memento to Professor Adelman. Over to you both.
Well, we have known each other for 32 years now. We can't hear, your mic is not working. Am I audible? I think
the mic.
I think it should be working now.
Check, check. No.
Yours is on.
Am I audible in this? Is that better? Yeah. I've got a mic.
Probably better if they can't hear me. Well, as I was saying, we have known each other now for 32 years, and we have a common friendship with Upendra Bakshi, who has written the foreword to the new edition. And thank you for inviting me. I'm very happy to be part of this Q&A. So the first question, I hope is not too broad, is what made you write this book, the first edition, and now the updated edition?
Well, after I finished my master's at Warwick, I decided to do my doctorate, and I was in search of a topic for my doctoral thesis. My father, who was a pre-partition lawyer, he became a lawyer in 1944, suggested, why don't you look at the Kashmir issue? This is one issue where every conceivable principle of law has been turned on its head to create and sustain this issue. So that's what, I mean, we always thought of Kashmir as a political issue, and it is a political issue. But that kept me, started a thought process. Does it have an element of law in it? Is it something worth a doctoral thesis? I was already practicing law at that point of time. And so I decided to see Kashmir as, I mean, I'd never been to Kashmir. I knew nothing about Kashmir. The idea was, let me collate the facts about Kashmir. The way we do a case, the client gives you a bundle of facts, and we evaluate those facts. Then we stitch them together and present an argument. So the idea was, let me collect information about Kashmir, the entire issue, what is this issue, and give my own evaluation of it, and then see what is the way forward. Why did we have this issue? How was it created? And what is the way, in a way, to resolve it? So the book, I mean, I write as an Indian. I write as a person who suggests to the government of India what New Delhi should be doing. But more importantly than that, this is a professional opinion about what the Kashmir case is. Even if I belong to some other nationality, my assessment, my professional opinion about the Kashmir case would have been the same. And once I took that approach to see, treat Kashmir as an ordinary case dispute between A and B, then I realized there's a story to be told. And that's how this book came about.
So you provide a very detailed history of the dispute, but is not part of the problem that the facts are disputed. There are no common facts.
More than the facts being disputed, actually the facts have been quite, they've been documented by many, many scholars, and there is some common underlying facts. But more than the facts, I found that there are different perceptions of what is the Kashmir issue. Everybody seems to have a different take on it. As far as the international community is concerned, it's a tussle of territory between India and Pakistan. As far as Pakistan is concerned, a Muslim majority princely state contiguous to Pakistan should go, be part of Pakistan. According to India, Kashmir issue over the years became equated to Article 370 of the Constitution, giving a special status to that region. According to the Indian security forces, it's a law and order problem, supplemented by a very generous export of cross-border terrorism by Pakistan. As far as the Kashmiri Muslims are concerned, they see Kashmir issue in the prism of self-determination, promised by the tallest of Indian leaders. As far as the Kashmiri Pandits are concerned, they see it from the perspective of being a refugee in their own country. As far as Jammu, even Kashmir, Jammu and Kashmir, when we say Kashmir, it is the entire state is Jammu and Kashmir and Ladakh. These are heterogeneous areas. And there has been this perception that there's a hegemony of the valley over Jammu and, as far as Jammu and Ladakh. So there are many different layers of the Kashmir issue. And in my view, these layers are important, but none of them is the crux of the Kashmir issue. According to me, the crux of the Kashmir issue is the conferral of a disputed territory tag on the princely state on the international plane. Because if you just go back to see, when you talk about facts, what are the facts? Once princely state, 3 countries have parts of it. India has about 45%, Pakistan has about 35%, China has about 20%. China has got nothing to do with Kashmir, but China has about 20%. And it's through this part which China has, they have this, through Gilgit-Baltistan, and the parts of the territory with China, they have conceived this, the CPEC, the China-Pakistan Economic Corridor. Now there's this political stalemate, and the point is, how do you break it? Because otherwise violence is going to continue, this problem is going to continue. So, do we have a diplomatic solution? India's parliament has told Pakistan, please vacate. Pakistan is in no mood to indulge. India's blanked out China. We don't even talk about China. We say it's a bilateral issue. So there's no diplomatic solution. There's no political solution. There's no economic solution. There's no military solution. How are you going to break the political stalemate? So the book actually, when we talk about, these facts are all admitted. The perspectives are different based on the same facts. And the book actually talks about how do you go around trying to break this political stalemate so that there is eventually some movement on the Kashmir issue.
What prompted this new edition was that the abrogation of Article 370 in 2019?
Well, yes and no, because the first edition came out in 2016. And I had, following my father's suggestion that of examining it, I thought about what can be a way of resolving the Kashmir issue. And I thought, well, why don't we use law as a tool to break the political stalemate, to depoliticize the Kashmir issue? So that is a common thread between the first edition and this edition. Broadly, it is, well, law can't resolve anything. Law by itself can just state what the position is. It can't resolve any issue. But law has the potential of altering the political discourse, of setting the narrative. So the idea was, and whenever there's a dispute, whenever there's a controversy, the best way to depoliticize that is to check the legal standing, legal underpinnings of that particular issue. So the idea which came when I was going through this, because this was a legal doctoral thesis, prompted by my father, which said, test the legal stand of India and Pakistan and the international community and the United Nations on the Kashmir issue, the answer lies there. So the idea was that can we use international law to be able to break the political stalemate and move forward. The first book came in 2016, where I had suggested a particular recommendation. The government of Pakistan apparently had been following the book, in my view, quite closely, so they had passed some resolutions which forced me to take out the second edition, more or less in 2017. And then you had the abrogation of the Article of 370 in 2019, then the Supreme Court decision upholding that move by New Delhi. And so that led me to say, well, I anyway have to now update the book. I anyway have to talk about what is happening now. Kashmir is something that's always in news, and it's always it's always dynamic. Things keep changing all the time. And as it so happened, the earlier publisher closed its publishing division in India. And so I had to find a new publisher. So I said, very well, let me rewrite the book in a way to bring into account the subsequent developments. But the central theme remains the same. The central theme remains the same from what it was when I gave in my doctoral thesis in 2001. That is theme permeates the first edition, the second edition, and this third edition.
So, Baroness Nicholson, she is the politician, and we are two lawyers, but isn't the path towards a legal solution fundamentally political?
Well, law is politics. And you're altering political relations through law. I mean, even if you give me a court decision, you're altering political status. But the view, you see, in this particular case of the Kashmir issue, actually I started by going by what Churchill has said. And I think I have the quote somewhere in the book. Yes, he has said, the further backward you can look, the further forward you can see. And so the idea was, while we are examining the legal basis, and of course the legal theory is also, law crystallizes the political decision at the end of the day. Why are we in this position? And that took me back into, the book starts with 1600, when the East India Company decided to come with the adventures of trading. And it goes on, this book of course goes on till 2024, up till the Ukraine conflict, and also the Gaza, what's happening in the Middle East. So it covers this entire, as one line of argument. If I just elaborate a bit on that, this book, there's an Indian narrative about what happened on the subcontinent that led to its partition. There's a Pakistan narrative as to what has happened on the subcontinent. I decided to get into the British narrative as to what has happened on the subcontinent. And the British are known for keeping notes. And their bureaucracy is such that everything is documented. So once the British archives are declassified, they actually disclose a completely different narrative about, and I won't get into that because we don't have the time and that's not the occasion, but that, if I simply summarize, simply talks about the British policy of communalizing India after the First War of Independence in 1857. You might have had religious persecution under one community or the other, but there was no communalization of the polity. Hindus and Muslims were living side by side. They'd grown to have an Indo-Muslim unity of culture, if nothing else. So there was a deliberate policy of communalization exposed by the exchange of telegrams between the Viceroy on the subcontinent and the Secretary of State in London. My finding, which is there in the book, whoever would like to go through it, based on British documents, is that the partition was scripted by the British way before 1947, at the time when India did not support Britain's Second World War effort. I put telegrams there which talked about the Viceroy telling London that we have asked Rafullah Khan, member of the Executive Council, to drop the maps of the dominance. This was 1940. How the two-nation theory was formulated by the British to be mouthed by Jinnah. It's all in the British documents. And being a lawyer, I have to cover my back. So everything has got authority, it's got a reference. How not only the partition was scripted, the British actually wanted, if you see the map of the world, right from Turkey to China, there's Islamic belt which straddles the then Soviet Union. The British wanted that Islamic crescent to be intact for the great game against Soviet Russia. There are a lot of politics, international politics there. If anybody's interested, they can examine that part. But they wanted northwest frontier province of the undivided India, Gilgit-Baltistan. And when J&K acceded to India, J&K was a sovereign country as of 15th August 1947. It became an integral part of India on 26 October 1947. I've documented how the British Gilgit Scouts carved out Gilgit-Baltistan within 5 nights. After that territory had become Indian territory, hoisted Pakistani flag and told Peshawar, you take it over. How it was British army chiefs heading Indian Pakistan armies which decided to create a buffer area called the so-called Azad Kashmir, so that India, if it goes to war against Pakistan, to recover this territory, it will liquidate Pakistan, defeating the very rationale of partition. So how these 2 areas were earmarked to be kept free from Indian control. I've gone through about 80,000 pages of UN Security Council reports to show how the United Nations Security Council proceedings were subverted, how they were scripted. It was a trap which was for India, that India would go to the United Nations Security Council complaining of aggression against its territory, and will be forced to hold a ceasefire without requiring Pakistan to vacate, so Pakistan could keep that territory, de facto control of that territory, and give it to the British for their use for the great game against Soviet Russia. So all that has been documented from authoritative sources, including UN Security Council reports, from British archives, from telegrams, and this is all matter of documentary evidence. So when you're studying, when we go through this whole process, you realize that it was the Kashmir issue was deliberately created. It has been sustained due to, I would say, mishandling by the leaders of the successive governments at New Delhi. Not one particular government, but something which I said right from 1947-48, we messed it up. And that is continues till date, in my view. So there is a lot of, when you talk about why do you go back, the history, etc., there's a whole reason to show why we have reached to this stage. And unless we undo our past mistakes, we cannot find a way forward.
Aman, are you perhaps placing too much faith in international law, given that the parties have to accept the jurisdiction of the International Court of Justice? And is it really feasible to envisage India and Pakistan, leaving China out for the moment, both accepting the jurisdiction of the court?
Well, Pakistan had accepted the jurisdiction of the ICJ by a resolution of 1960. India had kept its Commonwealth reservation saying we'll refer what we want to refer. And that was the implication of that. So the first edition talked about Pakistan having already accepted, and India should make a reference to United Nations, to the ICJ, on 8 legal propositions. Within a few months of that book being out, Pakistan withdrew, and I'm talking about 2017, Pakistan withdrew its 1960 resolution, because they knew that if India goes to the ICJ, what could be the implications. And that's what led to the second edition. Now, when we talk about faith in law, um, law is not the best way of dealing with international relations. And that's, I mean, nobody says it is the best resort, but you don't really have an option. Those who say, why go to the ICJ? We are in control of the territory. 370 is gone. Why put yourself under judicial scrutiny? The point they miss is that 370, what they're talking about, the territory which is with us, is only 45%. The rest, more than 55% of territory, is still under foreign rule. It is still under rule of Pakistan and China. Those are Indian citizens under the Indian constitution. They are not Pakistan citizens under the Pakistan constitution. They are not Chinese citizens under Chinese constitution. Till date, 55% of the territory of the former princely state is still under foreign rule in 2024. What are we doing about that? None. I've read books and books. This research started in 1995. We're in 2024. I've yet to come across one solution which has been suggested to say, how are we going to get back that 55% of territory? How are we going to get back our people? Even those people have lost their consciousness of being Indian citizens. Generations have passed. There's no debate in India about getting back those people. Of course, we have statements coming that we'll get back POK. How? So no scholar, no commentator has actually put a roadmap together as to how to get it. And I'm put a roadmap in the book. I'm not saying law will resolve it, but it will alter political course, and I'll explain how. But so when we talk about the faith of international law, it's not because it's the best resort, it is because it's the only resort. Because you don't have a diplomatic, political, military, economic solution. So that's the only one way by which you can try to get some movement on the Kashmir issue. I'm not on the issue of enforceability. China did not accept the arbitration award. Pakistan will say, well, we're not bound by the findings of the ICJ, or we don't agree to it. Even if you go for advisory opinion, one is to take a consent. There are many routes to get into the ICJ. It could be through advisory opinion, it could be through a reference made by the Security Council under the Charter, because the Security Council is still seized of the Kashmir problem, India-Pakistan question. It could be through a General Assembly resolution. But at the end of the day, the Security Council has to enforce it. And the argument would be, they won't. So why go? But then that overlooks the fact that even a declaratory judgment can alter the political discourse. It can enhance New Delhi's moral authority to be in J&K. It can tell the people of J&K that we are right. You are part of India. So there are many value. There's a lot of there are a lot of benefits of even a declaratory judgment of the ICJ. And if it goes with the consent, and if the ICJ gives findings in India's favor, and we can talk about what the ICJ, what do I suggest, why we should go to the ICJ, we can talk about that. But if the ICJ suggests, holds in India's favor, you have already precedents of Namibia, Nicaragua, so many judgments which bring about, lay down the legal consequences of a decision of the International Court of Justice. Brings in the international mechanisms to say the very presence of Pakistan and China there amounts to aggression. They have to make reparations. So there's a whole new area that's not even been explored so far.
The Security Council is deeply polarized. Is there any possibility of the General Assembly asking the ICJ for an advisory opinion?
See, before we even come to the stage of how to get into ICJ, whether through the General Assembly or otherwise, there has to be a clarity on the legal position, because that's what the book is all about. depoliticizing the Kashmir issue. It's a political issue, separate the legal from the political, get a finding on law. But what finding in law are we talking about? And it's only that, once that is understood, perhaps this criticism or those who are skeptical about going to the ICJ, they could perhaps be persuaded. And so perhaps it is important to start first is, what is it that should be India's stand? And this is where I talk about, regardless of my nationality, as a lawyer, how would I analyze the Kashmir issue or the Kashmir case? So I'll put it very simply, because I understand a lot of the audience may not be lawyers. So I'll put it as simply as possible. Now, India may be a very ancient civilization, but modern day India and Pakistan are creations of British statutes. The Indian Independence Act of 1947 and the amended Government of India Act of 1935. The partition agreement between the political parties, Congress and the Muslim League and the British, all the affected players, the players at that point of time, that partition agreement was reflected in this British statute. So there was a political decision which was crystallized into this law. Now, under this particular law, Punjab and Bengal had to be partitioned on the basis of two-nation theory. There was supposed to be a referendum in the Northwest Frontier province, and I've talked about the smoke screens that was created by the British to let the Indian National Congress, which was holding power in that province, to hold a referendum and abstain from standing in that referendum, so that that province goes to Pakistan to make Pakistan materialize. Northwest Frontier province is hilly, and that's why the plains of Punjab had to go there, so the politics behind it, so that's a slightly different point. But the scheme of the statutes talked about referendum in Northwest Frontier province, partition of Punjab and Bengal. But for the princely states, Jammu and Kashmir was a princely states, the provision was that the sovereignty would revert back to the rulers. The British sovereignty would lapse. After the First War of Independence in 1857, there were certain developments on the subcontinent. One was that the role of the East India Company came to an end. You had the Government of India Act of 1858, and the British Crown took over. The second consequence was that the British said, we won't annex more territory. It is sufficient if the rulers owe their allegiance to the British Crown, external allegiance. Internally, they were sovereign. So, in 1947, when the British statutes came, they said the sovereignty would lapse. So you have about 560 odd sovereign countries. And of course, how they all different countries went to different states went to Pakistan or India, that's a different story, which is also in the book. Junagadh, Hyderabad, that is also in the book, and so on and so forth. But this statute said that the sovereignty would lapse, not lapse in the people, would lapse in the ruler. The implication would be the ruler becomes the sovereign in this monarchy. The ruler would be sovereign for that state. The ruler would be executing an instrument of accession to go to India or Pakistan or stay independent. All three options are open. J&K didn't want to come to India or Pakistan. The ruler had got Nehru arrested in Kohala in 1946. Sheikh Abdullah was talking about democracy. The ruler did not want to go to Islamic Pakistan. He was from the Dogra community. The book talks about the tribal invasion, etc., and that's one part of it. But this particular law gave the power to the ruler to accede to India, Pakistan, or stay independent. The ruler acceded to India under this law. So the very law that created India, modern day India, made Jammu and Kashmir an integral part of India. Because these statutes created India and Pakistan and told the princely states, go to India, Pakistan, or stay independent. Jammu and Kashmir came to India under that very law. So the very law that created modern day India makes J&K a part of India. it's fair to say that the very law, the same law created Pakistan. So the very law that created Pakistan makes J&K part of India. Pakistan can't disown that law. If it disowns that law, there is no Pakistan. It's a unique situation where one statute has created two sovereign countries. Both sovereign countries, which are creations of the statutes, have accepted those statutes. We could have done away with it, but both India and Pakistan have accepted it. They are sovereign members of the United Nations as creations of these statutes. There's no doubt of a legitimacy for India and Pakistan. So if that is the position, then from where did, and this was a constitutional law governing India and Pakistan, then where did New Delhi in 1947 get the jurisdiction or the power to say that the future of this princely state will be decided not by the ruler, but by the people? None of the other 560 states had been given that option. Even for Junagadh, Hyderabad, where plebiscite was held, the ruler approved or ratified that decision, the legitimate source of authority. But the ruler of J&K has said, I have unconditionally acceded to India. The government of India had no power to introduce wishes of the people to test the accession or the future of the country. Now, if that is the situation, if you think, let me put it in a very layman's situation. I have a house, which I have a title to a house. I then say, I'm not too sure I have the title because I accept it provisionally, subject to ABC. Somebody gets in, I say, please get out. They say, well, you don't know your own title. I say, this is a terrorist movement. They say it's a freedom struggle. Who will decide?
So if you were a judge on the ICJ,
Yes.
how would you start to resolve the sovereignty issue?
So there are 5 chapters in this book which has been added, which talks precisely about that. It gives precedence at least of another 20, 30 issues of sovereignty, territorial integrity, what is the rules, effectivities versus the other norms of international law. What is the principle by which the ICJ, the whole jurisprudence right from 40s till 2024 has been summarized out here as to how the ICJ will have to decide this particular issue. Because this is not the only case of territorial title which is before the ICJ. There have been so many cases there which have been listed here. The principles have been culled out in the book to say apply the same principles. If the law that created India and Pakistan, because also think about it, the princely state came to India, it was New Delhi said we'll accept it provisionally subject to a reference to the people. So it is New Delhi which created doubts on its own title to J&K. It is New Delhi which went to the United Nations, took and made a statement there that we'll have a plebiscite. So something which was a reference to the people within India's domestic jurisdiction, it is New Delhi which internationalized it. It is New Delhi which gave standing on every country in the world to comment on J&K. It is New Delhi which facilitated, by saying we'll have a plebiscite, which facilitated the conferral of the disputed territory tag on the international plane. If that is the situation, then it is New Delhi which has to confirm, and I use the word deliberately confirm, its own title to J&K. And for that, you would need to go to a body whose views are authoritative, whose views are binding on the world community. And the only authority in existence I won't go to the political organ, the United Nations Security Council. I would rather put my faith on the judicial organ, which is the ICJ. The book talks about that should the matter come to the ICJ through whichever route we're talking about, whether it's advisory or whether it is through the United Nations Security Council itself or with the consent, express consent. How would the ICJ decide with it? Can the ICJ get into something which is seized with the United Nations Security Council? And the answer is yes. Can the ICJ, what are the principles by which they will have to decide? I've made a brief It's like a lawyer giving a brief to somebody. It's all there. Material is all there. These are the judgments. Just apply it. Can China intervene? No, because unlike domestic law, affected third party who says I'm affected, hear me also, that proposition doesn't hold in international law. What are the consequences of ICJ decision? If ICJ decision, I formulated 8 propositions, or legal propositions. If ICJ gives a decision on those 8 legal propositions, in my view, 80% of the Kashmir issue will be resolved. Because then you need to create the political will to give effect to it or to change the political discourse. But that view would be binding on the world community. If ICJ says, yes, as per the very law that created India and Pakistan, J&K, the entire territory of J&K is part of India, then you're challenging the entire political discourse as it exists today. And should the ICJ let down that faith, bring politics into it, and simply say, well, wishes of the people are relevant, very well. Those who have studied the history of Kashmir would know that the ruler had transferred his sovereignty to an elected state constituent assembly. That state constituent assembly was representative of the Kashmiri population, and they have passed a resolution saying we want to be an integral part of India. So the wishes of the people have been ascertained. We don't lose anything.
Do you think India should accept the jurisdiction of the ICJ as a way of opening up a path to the court?
I feel New Delhi, it's a political decision. And one is the legal part, the factual part, other is the optics of it. And that's why it's a political decision. But the way I see it is,